The Supreme Court of Ohio considered several important legal issues when it conducted oral arguments in September. The court heard 8 cases, including a family in Montgomery County requesting a new trial in their medical malpractice case. Harold Price died while under the care of 3 physicians in the Dayton area. His family filed a medical malpractice case against the doctors, and the trial began with jury selection in Montgomery County Common Pleas Court in 2023. The trial judge told the prospective jurors they were going to hear a civil case and explained the level of proof Price's family would have to provide to find the doctors committed malpractice. Price's attorneys claim that when they were told the level of proof needed and the family was seeking $30 million, 4 possible jurors expressed concerns. Some told the judge they would expect the family to provide a higher level of proof, especially given the requested dollar amount. Price's attorneys were able to use 2 of their challenges to exclude 2 of the possible jurors. They asked the judge to remove the other 2. The judge refused, finding that when given more instructions, the jurors indicated they could be impartial. The family lost its case and appealed the decision. The appeals court upheld the trial court's decision. The family then appealed to the Supreme Court, arguing that once a possible juror indicates they can't be impartial, a judge must bar the person from serving on the jury.
The jury knew exactly what the burden of proof required, and yet some of these jurors, including the wife of a physician, said, I'm going to require more in a medical malpractice case than the burden of proof.
But tried by the court means a court has to try them.
And Justice Wine, that takes me back to a point I made earlier, which is our proposed rule is that that trial occurs when the trial court is able to confirm that a juror said what counsel believes the juror said, and no more.
Attorneys for the doctors told the court the trial judge had discretion when determining whether a person can serve on a jury. In this case, the judge appropriately seated the jury.
When the challenge was made, the court was reviewing the entirety of the voir dire process, including questions that the court had asked herself, where she said, here's the burden of proof. Does anybody have any issues with following it? And nobody says no.
So isn't that some of that dependent upon the trial judge's own methodology for conducting voir dire?
Certainly that may impact the process in terms of when challenges are made and when their validity is tried. Here, I don't believe that was an issue. The challenges weren't made until at the conclusion of the questioning of the prospective jurors.
In another case, the court heard a claim from an Allen County man that he deserves to have his rights to carry a firearm restored. Patrick Heffley was convicted of a felony offense of domestic violence in 2006. Because of the felony, both state and federal law prohibited him from having a firearm. In 2023, he applied in state court to have the restriction, or disability, lifted. Heffley told the court he completed his prison term and fulfilled all of the requirements related to his conviction. The trial court noted that under state law, the court could not grant his request because he is prohibited by federal law from possessing firearms. Heffley appealed the decision. An appeals court found that under state law, it could restore his civil rights, removing the federal law restriction. The county prosecutor appealed the decision to the Supreme Court. The prosecutor argues that a state court cannot restore the applicant's firearm rights. The federal government must first restore the rights before the state can act. The argument drew questions from the justices.
Isn't he caught between a rock and a hard place?
It is effectively one statute saying the state, you go first, and the state statute saying federal disability, you be removed.
Right. So what's he to do?
He's to, in this case,
I'm asking the state of Ohio, what's he to do to get his firearms rights back?
Sure, he can petition but
they won't give it to him in the feds.
Well, they could. He could file it in the district court as well. He could seek a pardon. Those actions are all available. The statute simply just doesn't permit the remedy Mr. Heffley seeks, and the General Assembly is free to clarify that if they so wish to choose to do so.
Do you think the result that you're advocating today is what the General Assembly intended when they passed the statute? I know the statute may say something different, but do you think that this is what they intended? That there was no way to get relief for this?
Do I think
you're in this catch-22 circle?
The problem is is it what they intended? It might not be what they intended, but it's what the plain and unambiguous language of the statute they enacted says.
Heffley's attorney reiterated that the prosecution is wrong and the state law allows the trial court to restore his rights to own a gun.
What are the sources of your disability? Is this something that Ohio can relieve? If yes, then once Ohio restores the rights, they're no longer considered convicted for federal purposes, and therefore no longer under that federal disability. Again, he wouldn't be considered convicted for the federal firearms purposes if his rights under state law were restored. And this happens by operation of law. He wouldn't need to make any further application to the federal government. It is simply by operation of law. If the state restores your rights, then so does the federal government.
You can follow these and other cases before the court by visiting our website at supremecourt.ohio.gov and signing up for case activity notifications. The court meets for oral arguments at the Moyer Judicial Center in Columbus. Each session begins at 9 a.m. You can also see them live online at supremecourt.ohio.gov.